Employment litigation is not for the faint of heart. I'm sure that all of you, when you've received speeding tickets, have been inundated with advertisements from law firms who want to represent you in a speeding ticket situation. You know, it's the opposite in employment litigation. In fact, being a plaintiff side employment lawyer is considered one of the hardest areas that you can practice in. And the reason for that is we're faced with proving intent. So what was in the supervisor's mind when they were deciding to lay off or terminate an employee? And when there is a discriminatory intent, it's often concealed. And so it becomes quite a steep challenge in order to try to reconstruct what was in that supervisor's mind. And you know, it's not unlike a coroner looking at a dead body and trying to figure out what the cause of death was. You know, we're doing the same thing, but looking at evidence around a termination decision. So it's not an easy area of law to practice in. So in order to be good as a plaintiff side employment lawyer, really it's something that you need to be called to do. Now, Abe Lincoln had a saying and an adage, you know, for other trial attorneys like himself, and it was actually to discourage litigation and to persuade neighbors to compromise whenever you can. And as a member of the bar and in this community, I also think that that's my first task, and that if I can be successful in being a productive force and resolving a case without it going to litigation, you know, that's really what I'll strive hard to do. And so although we're a law firm that loves to be in the courtroom, feels that that's where we're meant to be, we don't rush to get there. And so our first approach in negotiations is to extend an olive branch to an employer and to give them an opportunity to resolve things amicably and confidentially. And I feel like we owe that to our community. I mean, the fact is our judges are extremely busy, and the jurors that would be sitting in this trial, they have jobs, they have families. Some of them will not have food on the table because they're sitting on a jury for a week. And so we always want to avoid litigation whenever we can. The problem is that, and it's really shocking to me, how often employers and companies will refuse to settle a case early. And I don't know if that's hubris or it's arrogance, or maybe it's because that company had never been held accountable before, but 9 times out of 10, the right decision for an employer is to settle an employment litigation case early. And sometimes it can take weeks or even months of us negotiating with an employer and holding a mirror up to their face in order for them to realize that they have a problem and that they should resolve the case. But on the flip side of that, it's also true that we don't have a whole lot of clients that come in and say, we want to have a trial. In fact, most folks that are sitting in our conference room have just lost their jobs. They're worried about their income, ability to pay their mortgage. They're worried that they're going to have to take 401k money out, to be able to support their families. And they also have non-economic concerns, like what sort of reference am I going to be given? Can the company legally disparage me? What about this non-compete agreement? Is that going to prevent me from getting a new job? And so, we understand that, oftentimes settlement is the right choice for our clients as well. Now, there are advantages to hiring an aggressive plaintiff side employment discrimination firm to negotiate on your behalf. And the reason for that is, there can be no bluffing when it comes to negotiating a severance or an early termination. The lawyer that's involved in that effort has to, on the one hand, be diplomatic and sort of be a potential peacemaker in a situation and extend an olive branch, but on the other hand, also needs to be holding a bat, which is the litigation that would follow in the event the employer isn't willing to be reasonable. At Van Kampen Law, we're not a law firm that barks, or bites out of the gates. We certainly do try to play nice. What I've endeavored to do as a plaintiff's attorney is on the one hand, to be respected and feared, but on the other hand, to be liked. And so, I'm always gratified when we get referrals from management side employment lawyers who we've litigated against when they have a family member who's lost a job, or a close friend or one of their clients, because of their experience with litigating against us. And I do feel like the previous successes that we've had for our clients has translated into earlier and better settlements for our current clients. So it's a hard job being a plaintiff side employment lawyer, but it is so rewarding. I always think to the first interaction that I have with a client when they come in for a consult, and you can see the worry and the stress on their face, and I ask them how they doing, and they don't even try to say they're doing well, because they're not, and it's a really tough time for them. But if I could just capture the expression on their face when we get their case settled, for example, at a mediation, I mean, it's like seeing a transformation in a person, and And knowing that, that those good vibes that then are going out into the world as a result of that, or that there's a greater impact for the community as a whole. And the other thing that I really like, and I certainly didn't encounter this when I was a management side employment lawyer, is getting invited to a client's family Christmas party, for example, or enjoying a transition from a client relationship into a close friendship, which has happened with several of my clients as well. And so regardless of the financial outcome for the firm, it's that sort of goodwill and good feeling that makes this all worth it.